a further concern regarding the evaluation of T-Systems bid. The first issue was the conflict of interest, which I dealt with before lunch. And the second issue pertains to the rounding off of scores that T-Systems were given for functionality. Now, I should point out that there was a threshold for technical compliance, which was set at 70%, sometimes referred to as the functionality threshold. And T-Systems had missed that threshold by a fraction. T-Systems had scored 69.93% and not 70. We then had regard to the what the regulations said about this, and we saw that the 2011 regulations had a provision dealing with how scores are to be rounded off. It is contained in Regulation 11.4 of the PPPFA regulations of 2011.
May I refer you to Exhibit BP 2.1C. It will be a different file.
That's file B, is it?
BP 2.1C.
A C, yes.
Yes, C. And then if you may turn to page 874.
Yes, I am there.
Is that the regulation that you are referring the chair to?
That is correct, Chair.
And then may you turn then to page 885 with particular reference to paragraph 11.4. You may read it into the record and confirm whether does that accord with your evidence.
Chair, the regulation reads as follows.
I'm sorry, what regulation and what paragraph?
We are at page 885
Yeah.
with particular reference to 11.4.
Or regulation 11,
Yes.
sub-regulation 4.
Yes.
Okay.
Chair, the regulation reads as follows. It says points scored must be rounded off to the nearest 2 decimal places.
So this is what you are referring to that raised serious concern with the scoring of the T-system.
That is correct, Chair, because even if you round off 69.93% to the nearest 2 decimal places, regardless of what that third decimal would have been, if you round it off, T-system still doesn't make the functionality threshold.
What does rounding it off to the nearest 2 decimal places, what does that mean?
Well, if you look at this example here, Chair, if you look at someone who scores 69.93%, to round it off to the nearest 2 decimal places, my understanding is one would have to look at what the third decimal is. So let's say the third decimal was 6, so it is 69.936. Because that 6 is higher than a 5, it would have changed the 3 to a 4, but that still would not have had a knock-on effect to change the overall score from 69.93 to 70.
I'm sorry, what do you understand the application of that sub-regulation would be if you applied it to 69.93%?
What I understand this to be, Chair, is that to round it off to the nearest 2 decimal places, one would then see, well, what would that second decimal place, how would you round it off to that second decimal place being the...
I'm very bad with anything mathematical.
Wouldn't that still be at
I only did arithmetic and a little bit of maths at school. So remind me what we talk about when we talk about a decimal or two decimals, decimal
Yes,
places.
Chair, let me try my best on
Oh, that is if you know. I'm
Yes.
assuming you know.
Yes, yes.
Yes.
So if one has to round off to the nearest two, the intent here is to see whether this score of 69.93 can be rounded off to 70%, because if they make 70%, then they are through.
Yeah, but now
But-
you are talking about, of course, I know that I spoke about the specific example. Let's start with the general. What is two decimal places? What is one decimal place?
Okay, so the first decimal place would be the decimal place after the point. So under if you look
Oh,
at
what-
69.9, that is, the 9 would be the first decimal
The first 9 would be the first decimal after the point.
after the point.
Yes, and then the digit that comes after 9, whatever it is, would be the second
That would be the
decimal.
second decimal.
Yes, so but then if it says round it off to the nearest nearest
Two
Two
decimal
decimal.
places.
places, what does it mean? It doesn't seem to say to me, maybe it's because of my not understanding issues of decimal. I mean, it doesn't say anything like round it off to the nearest 10, for example. So if it said that, and it was 69.92, you would bring it back to 69.90, I would imagine, more or less. But if it is 69.97, then you'd bring it closer to what is closer, which would be 70. That's my kind of thinking. That's what I'm looking for.
Let's deal with it on practical terms. Let's take the score of 69.93, and then let's say that you wanted to apply what the regulations say. What would be the score of T systems?
Just before I answer the question, the one way to round off is just to round off to the nearest whole number.
Yes.
So if I have to round off 69, let's say 69.9.
Yeah, if they say round it off, it's clear you must go to 70.
And exactly, because that 9 is above
Yeah.
5, and that has a knock-on effect,
Yes.
which then changes 69.9
Yes,
to 70.
yeah.
When it says I must round it off to the second decimal place, I would, for that decimal place of 69.93,
Yes.
for that to change, I would have to look at what the third decimal is, because if the third decimal is under 5, it stays as a 3. If the third decimal is above 5,
Yes.
then the 3 becomes a 4.
4.
But even if that 3 becomes a 4, the 4 is still below 5, so it doesn't have a knock-on effect of changing that 69.9 into a 70.
But even fundamentally, it doesn't even go to the functionality threshold.
And it doesn't pass the functionality threshold.
But then go back to the questions of, I understand what you're saying, but the chair wants to understand what you're saying.
Well, maybe you can help me if you understand.
He has gave you the answer, Chair, that 69.93, even if you were to apply 11.4 rationality, it won't go to the threshold of 70. At best, it will be 69.96 or 5.
No, I think I understand that, and that's part of what he has said.
Yes.
but I'm not sure if, if you talk about rounding off, you could have a situation where they say round a figure off to the nearest 10. Well, I don't know whether they would say 10, but in terms of what I have in mind is that if somebody has got 12 points and you are required to round off to the nearest, I don't know whether you would say 10 or something else, but you would have a choice of rounding off and put somebody at 20 or at 10. And if they are below 15, the nearest 10 would be to give them 10. But if they are above 15, the nearest 10 would be 20, if you understand what I mean.
Chair, can we do, without having to go to charge you anything for arithmetic 101, can we go to this number, for instance? If you can write this number for me, maybe I might make a better example for you. If you have a number like if you can write it down, 4.732.
Somebody who knows maths and so on must be laughing at us, or at least at me, laughing at me. Yes.
And then if you want to move it 2 decimal places, that number, it will either round up to 4.73 or 4.74. Would I be correct, Mr. Volmik?
Okay, so my understanding is this, to use your example
Yes,
of 4.
and we'll apply it to the 69.93 very quickly.
Yes, 4.732.
Yes. And I
To
move
round
it
off to the nearest
two
two decimal places, I must see what is that third decimal.
Exactly.
Now that third decimal is a 2, which is below 5. It has no knock-on effect, so it doesn't change that 3 into a 4
Yes.
or anything like that. So if I must round off to the nearest 2 decimal places, 7.32, to round off to the nearest 2 decimal places would remain
It will be
4.73.
Yes. At best,
It can't
4.7.
become a 5. And that is
Exactly.
exactly what the issue was in this particular instance,
But then-
69.93.
No, that's fine. I think from what you are saying, you're saying whatever application of this regulation one uses, it could never give them 70, or rather 70.
Exactly.
I will do my own homework about it. But I'm sure with Google and so on, somebody has already Googled and maybe having what a decimal is.
Mr. Pretorius is trying, but he's also hopeless in mathematics. He's giving me numerous numbers.
No,
So I'm not sure whether to rely upon his examples.
Lawyers can be very bad at figures.
And I'm no exception
But,
either.
okay, no, that's fine. Please continue. I'll do my homework.
The essence is what you have captured, Mr. Volmink, that
The essence is that when you round off to the nearest 2 decimal places, you can't change that 69.93 into
A 70.
It doesn't become 70,
70
regardless of what that third decimal place.
Do you know what the position would have been if it was 69.7 or 0.98 or 9?
69 point?
69.97
or 8.
or 69.98. Do you know whether it would make a difference on your understanding of how to apply this sub-regulation?
Well, if it was 69.97, one would have had to look at what that third decimal would have been, and let's say, so that 7 only changes if the third decimal is above 5. So let's say that was 69.
Yes, but that's what I've given you.
Yes.
Maybe I didn't make it clear. If on the number that we have got on your statement, we change 3 to 7 or 8 or 9, would it make a difference? Would the application of the sub-regulation make a difference?
Yes, what I'm saying, Chair, is that it would only make a difference if you know what that third decimal is, because the third decimal would have a knock-on effect. So to use your example, 69.9 says 69.973.
Which third decimal now?
Sorry, Chair?
Which third decimal now? Which one is the third decimal? Which one is the third decimal that you're talking about?
Well, in the example you gave of 69.97, we only see the
Yes.
second decimal, which is 7. We see the first decimal being 0.9, and then the second decimal, of course, is 7. But
Oh, yes, yeah.
yes, but to know whether that second decimal,
7 in that case.
you've got to
example.
look at what is the next,
Decimal.
the third decimal.
Where is the third decimal?
Whatever that figure is. I mean, in your example, it would-
Well, you have got here, before the point, you have got 2 digits. After the
Yes.
point, you have got 2 digits.
correct.
69.93. That's what you have in the statement.
Yes,
And you say this can't get you to 70.
yes.
Okay. So to see what could get you to 70, I tried to change and say, delete 3 and put 7 in the same number. Or delete 7 and put 8 or put 9. Would it make a difference? And I think you are saying it would not make a difference.
It wouldn't make a difference without knowing what the
The third
what
decimal
the third is, because it all has a knock-on effect.
Okay, all right. I'm sure after I've done homework, I will understand it better. Yes.
So that I think is the point, that that it wouldn't have changed 69.93 into 70. Chair, we then looked at what's called the implementation guide, which is a guide which Treasury issues to the triple PFA regulations, and I make reference to that in paragraph 83.2 of the statement, and I think that is set out in PV 11, which is on page 891.
891 of BB 2.1C. But the point,
I'm sorry, page 88,
it's 891.
891.
Yes.
Okay, thank you.
And Chair, in particular, we looked at paragraph 13.1.3. And it repeats the principle, which 13.1.3 is on page 907.
Yes.
And it says again, points scored must be rounded off to the nearest 2 decimal places. But this time, Chair, you will see that it is dealt with under the points allocated for price and preference only. There are certain points allocated for price, either 80 or 90, and for preference being 20 or 10. And the implementation guide seems to suggest to us that that this principle of rounding off to the nearest 2 decimal places only applies to that point allocation for price and preference, not for that earlier functionality stage, which we were concerned about. So then the question is, okay, so how do we round off to the nearest, at the functionality gate? If I can round off to the nearest whole number, then they pass, because it is 69.9, which then easily becomes 70. But if I have to round off to the nearest 2 decimal places, as our earlier conversation indicated, that wouldn't necessarily, that wouldn't pass them. So to resolve this uncertainty, we approached National Treasury to say, Treasury, we are dealing with rounding off of the score for technical, not for price and preference.
But before you approached Treasury, what was governance view about the idea of rounding off T-system score?
Governance was opposed to rounding off T-system score to the nearest whole number, it indicated to us that you had to round off to the nearest 2 decimal places, and our understanding is if that was followed, then they still would not have passed.
Yes.
So governance had a concern about that.
Now, when you first referred to the regulation that refers to this rounding off to 2 decimal places, you said something like that was a regulation that I think was for 2011 or had applied previously. I wanted to check whether that regulation was still applicable at the time you were dealing with this matter.
Chair, the regulation was applicable, to this
okay,
day.
okay.
Yes.
Now, the regulation or sub-regulation that you drew our attention to earlier, that refers to the 2 place rounding off to 2 decimal places. Did it apply to the price, or did it also apply to functionality? Because we have just made a comment in relation to what is at page 907 about it applying, I think, to price only, not to functionality.
Correct.
So I want to find out whether that was the same with regard to the regulation as well.
Yes. So if I look at the regulation, it doesn't say it applies only to price and preference or
it's general.
functionality. There's a general statement
Okay, all
that
right.
says points scored must be rounded off to the nearest 2 decimal places.
Okay.
But Treasury issues an implementation guide
Yes.
which explains how those regulations are to be applied
Yes.
in practice. And
Which
when
is what 907 is about.
Exactly, Chair. And it is in
Okay.
that context
Oh.
that we saw that principle of rounding off
Yes.
to the nearest 2 decimal places applies in the context of price and preference.
Yes. So, in other words, if the National Treasury instruction at page 907 wasn't there, then the regulation could be applied even to rounding off the score on functionality,
Correct, Chair.
because it did not have the restriction that the instruction had.
Precisely.
And your difficulty was, although the regulation seems to be wide in the sense that it doesn't restrict you to certain items where you can round off a figure, there is a specific instruction from Treasury which does restrict you. That was your challenge. That's why you referred it back to National Treasury.
You've summed it up perfectly.
Yes.
Yes.
Okay.
Now, what was the advice that you obtained from Treasury?
The advice is set out in paragraph 83.4, which is on page 37 of my statement, Chair.
Yes. Take us through it.
And it says that, well, Treasury firstly advised that the manner in which points are to be rounded off should ideally be set out in the RFP itself. We know in this case it wasn't. They then went on to say that if at the time of evaluation, the evaluation committee was dealing with decimals that were not anticipated at the bid planning, I'm quoting from what Treasury has actually said, and thus not dealt with in the RFP, then it said you can decide. You either round off to the nearest whole number or you can round off to the nearest 2 decimal points. So
Yeah,
in
you
essence,
see, when you say rounding off to a whole number, it sounds simpler.
yes, and I think that is what Treasury was saying to us. They
Yes.
said if you are dealing with functionality and you have got a situation like this where you've got someone who misses the margin, or the threshold rather, by a margin, then you decide. Are you going to stick to this principle of rounding off to the nearest 2 decimal places? Or are you going to round off to the nearest whole number?
Yeah.
And that being the case, Transnet then took a decision to round off to the nearest whole number.
Yeah.
in which case 69.93 rounded off to the nearest whole number became 70.
Yes. Yes.
And T-Systems, the net effect of all of this is that T-Systems
Got
passed
in.
that functionality
Yes.
threshold.
Yes. Okay. Okay. With this advice from National Treasury, was your unit satisfied? Because before it was opposed to giving T-Systems 70 on the basis of what the Treasury instruction says.
Yes. Satisfied may be putting it a bit strongly, but
Yes.
but certainly we engaged the
Yes.
authors of this document.
Yes, yes, yes.
And we asked the authors
Yes.
how one should deal with the situation
Yes.
of rounding off at the functionality.
Yes,
there.
yes.
And the authors then advised us that it was our
And you
choice.
just did what they...
And we then
Yeah.
implemented that
Okay,
advice.
no, that's fine, that's fine.
But Mr. Volmink, if you go to page 914, Chair, of Exhibit BB 2.1C,
Yes. 9-1?
914.
Yes, okay.
And then if you go to page, if you look at that document, that is the email which contain what Treasury ultimately advised Transnet to do. Am I correct?
That is correct, Chair.
But what I don't understand from your conversation with the chair, whether you are satisfied or not, is the fact that when you look at paragraph 3, Treasury says that it is important to emphasize that nothing, and it says nothing, on regulations compels the Bid Evaluation Committee to follow paragraph 2 above, as it will be based on the discretion of the Evaluation Committee and on the facts before them. But I thought that, you specifically referred to a regulation that stipulates in express terms what should happen, and you also referred to a subsequent communication from Treasury as to how this should be applied. Now, if Treasury says that this does not compel the Evaluation Committee to follow that paragraph 2, I don't understand.
Yes, so it's not that Treasury was saying to us that we were compelled
Yes.
to follow paragraph 2. What Treasury was saying is that if you look at the 2 bullet points, it gave us an option. It says you may round off to a full number, the nearest whole number, or you can borrow that provisions of that regulation 11.4 and round off to the nearest 2 decimal places. And what it says is that they are not compelling us, they're not compelling the committee to follow that paragraph, as it will be based on the discretion of the committee.
And where does one find in the regulations that you may round to the full number?
No, that's not in the regulation. It's not in the regulation.
It's in the regulation.
No.
Okay.
Well, the answer to the question that Mr. Mukwena has asked may mean that rounding off to the nearest whole number, which Treasury said was an option, may mean that it was neither in line with the regulation to which reference has been made, nor in line with the Treasury instruction to which we have referred, because the regulation to which reference has been made didn't talk about rounding off to a whole number. The only reference it made of rounding off was rounding off to 2 decimal places.
Yes.
So if you round off to a whole number, if that doesn't coincide with rounding off to 2 decimal places, you are not in line with the regulation. And then it wouldn't be in line with the national instruction, because the national instruction talked about 2 decimal places. So if you round to the nearest whole number, provided rounding off to the nearest whole number is not the same as rounding off to nearest 2 decimal places, then you could be in breach of both the national instruction and the regulation, isn't it?
Yeah. So Chair, I think the difficulty that was created is...
I'm just testing this because obviously you asked for advice because you wanted to do the right thing.
Yes.
But I'm just wondering whether the advice you were given was correct.
Yeah. Which is why I said, you asked me if
Whether
my
you were
unit was
satisfied.
happy.
Yes, yeah.
And I
yeah.
said that may be putting it a bit,
Yes,
a bit
yes,
strongly. But
yes.
we ultimately accepted
Yeah,
that this is the advice that came from Treasury. The fundamental problem is that the regulation, read with the implementation guide, deals with the question of rounding off only in the context of price and preference. The implementation guide explains that that principle applies only in price and preference. It does not say anything about how rounding off is supposed to happen at the functionality gate. So it doesn't say you can round off to the nearest whole number or you can't. It appears to be silent on it. And the advice of Treasury at the time is, in fact, I think they agreed that it only deals with price and preference. And then they said, when it comes to functionality, you decide. You have a discretion to either round off to the nearest whole number or follow the regulation.
Well, it might not ultimately be material, but one just wonders whether if the regulations are wider, you can restrict them by way of an instruction, because regulations are made in terms of an act of parliament.
Yes.
Can you issue a policy or something of lesser legal status and use it to restrict the circumstances to which it applies?
Yes.
But it might not in the end be material for our purposes.
There are certainly far more material aspects which you will come to.
Yeah, you would know better. Yes.
But this reflects the problems that you identified earlier on about certainty of regulations or the rules applicable to procurement, where they are not clear.
When the rules are not clear, Chair, then
It does create problems.
It creates problems. It is difficult for the organ of state to regulate its own conduct and regulate its own behavior and to know how it is to apply the rules in a particular context. And then one has to engage with the author of the regulation in the hope that what one then receives is the correct advice.
Yes. Now, from paragraph 84 on page 38, you are now dealing with the award of the tender to Neo 10. Mr. Volnik, could you please take us through that?
Thank you, Chair. Chair, we then come to the stage in the tender where we see that 3 bidders passed that threshold for functionality. They are Neotel, Dimension Data, and T-Systems. They were the only bidders who passed the threshold. There was some uncertainty around the pricing that some of the bidders had given, and there was a series of clarification sessions and clarification around the assumptions that were made. But after all the clarifications around pricing had been obtained, the final ranking of the bidders based on price and preference was firstly Neotel, who scored the most points for price, 90, at a price of 1.3 billion. And then Data came second, and T-Systems was ranked third. That was the ranking after the pricing had all been clarified and all processes had been followed. It would appear that after pricing had been clarified, T-Systems came and offered to reduce their price by a further 248 million rand. And I refer to that in paragraph 85, which you will find at the top of page 39 of my statement. So what happens, Chair, is that price negotiations were conducted, but then you get to a point where you invite best and final offers. All those offers must be in a box by a closing date and time, with clarifications and everything else. As a result of following that process, this was the ranking of the bidders: Neotel, Data, and T-Systems. With T-Systems' offer, after the best and final offers had closed, with T-Systems' offer to reduce by a further 248 million rand, it would have placed them in second place instead of Data. But the evaluation team, I think correctly in my view, felt that this could not be considered at that stage of the process, and they disregarded the further offer of the 248 million.
Okay, let's just step back, one step back. After the parties had put in their bids with their prices and the bids had been opened, then negotiations followed. Is that what you said?
Not immediately at that point.
Yes.
First parties went through that the functionality evaluation,
yes.
And then it got to the price and preference stage.
Yes.
And that is when the team who looked at the pricing,
Yes.
they felt that the pricing, there were some
Could be negotiated
ambiguities
down.
and so on, and bidders were invited to clarify their
pricing.
Their pricing.
And then at a certain stage to give their final and best offer.
Exactly.
And they gave that.
And they gave it.
Yeah.
And that was the end of that
of the
step in the process.
Issue. Yes.
After that,
Yes.
T-Systems, according to the report that they offered a further reduction of 248 million.
In circumstances where they had not been invited to do so and no other party had been invited to
Precisely,
do
Chair.
They unilaterally reduced
made
their
the
price.
offer. They made the offer. They say we can reduce this price, but they had not been invited, and no other party had been invited to enter yet a further round of pricing negotiation. But as I said, Chair, that amount was disregarded.
If it had been regarded, they would have been number 2.
Correct.
Okay.
And I will tell you in a short while that offer was then later taken into account by the Group Chief Executive, who moved T-Systems up to number 2, and Neotel was excluded based on various risk factors. But we'll come to that
Get there.
at a later stage.
Now, you make reference to a memorandum that was prepared and presented to the GCE, Ms. Shala Pillay at the time, who approved the award. May I refer you to Exhibit BB 2.1, C Chair, on page 967.
Yes.
Yes, I am there.
Yes, could you please identify that document for us?
Chair, this is the document which was signed by the then acting Group Chief Executive, Shala Pillay, in which she approved the award of the tender to Neotel.
Yes. And could you please read where it says purpose of the submission?
That is found on page 967, Chair, in paragraph 1. It says the purpose of the submission is to request the Group Chief Executive to approve the procurement process and award of business to Neotel, and then to sign a letter of intent for the preferred bidder, to also sign letters of regret for the 4 unsuccessful bidders, and sign the letter to extend the current Neotel contract.
Yes. And as you have pointed out to the Chair, at the time, Ms. Shala Pillay was the acting Group Chief Executive. Am I correct?
That is correct, Chair.
Now, may I refer to page 973?
Yes.
And you see that there are different individuals occupying different capacities that have recommended and ultimately approved the award. Am I correct?
Correct.
And what would be the significance of their signatures?
The significance, Chair, is that it would have gone through various people to review the submission, to ensure that the submission correctly reflects the outcome of the evaluation process, and then to take it to the person with delegated authority to approve the award.
Yes. And if you go to page 972, you'll see that there's a heading there that says approvals and delegations. Can you take us through that paragraph
Yes, it says
and comment on it?
that the Group Chief Executive has already provided the following approvals: approval of the request for proposal and advert to go out on the open tender, so that the tender has already long time ago been approved. The Group Chief Executive has also approved to advertise and issue the RFP to the open market for services for 3 years with an option to extend for another 2 years, and approval to conduct due diligence and negotiations on the network services RFP.
Yes. So, and at this time, Ms. Shirley Pillay was acting as a Group Chief Executive Officer, and clearly she had all the entitlement and the right to approve the tender as she did.
That is correct, Chair. These earlier approvals may have been done by the Group Chief Executive that I've just referred to now.
Yes.
But when Ms. Charlotte Pillay exercised the delegation to approve the award to Neotel, she did so as the Group Chief Executive, albeit in an acting capacity.
Yes. And that decision also enjoyed the support of all other senior officials who had the relevant authority to deal with the tender in question and the approval.
Correct, Chair. The officials come from the group strategic sourcing, the technical people, the governance people, supply chain officer, the chief information officer, the CFO. Everyone had looked at it and were happy for the award to be made to Neotel.
However, this decision that has underwent all these lawful structures and received approval from all the levels was ultimately overturned.
That is correct, Chair.
Can you tell the Chair how it was overturned?
Chair, I deal with that on page 39 of my statement in paragraphs 87 and following, where I make the comment that on the 20th of November 2013, a couple of weeks after Charlotte Pillay had signed off, on the 20th of November, Mr. Brian Molefe then wrote a memo to Anoj Singh, Mansika Motawani and Gary Peter, in which he informed them about his decision to rescind the award to Neotel, and he explained that he was going to award the tender to T-Systems instead.
Yes. May I then refer you to
Well, while Mr. Mkwena, sorry, Mr. Mkwena, while Mr. Mkwena is looking for the document to which we'll refer you, tell me, did the group CEO, Mr. Brian Molefe, have power to rescind an award that a tender that had been already granted?
I deal with
in
that.
terms of the policies and the
Yes.
procurement prescripts.
I deal with that a little bit later
Later
on,
on,
Chair.
yes.
And
Yes. Well, tell me whether yes or no. You can elaborate later on.
in short, in the context of this tender, no.
Okay, all right. Thank you.
May I refer to page 975?
Yes, I am on page 975.
Could you please identify that document for us?
This is the document that Mr. Brian Molefe had put together to explain his reasons for overlooking or rescinding the Neotel award and awarding to T-Systems.
Yes. And if you may refer to page 981. And the paragraph approval, and take us through those paragraphs.
What it says under the heading approval, it says, based on the explanations given above, I request the Group Chief Financial Officer, Group Chief Information Officer, and Group Chief Supply Chain Officer to note my decisions to award business to T-Systems in terms of Section 20.5 of the Procurement Procedures Manual, and I am overriding the recommendation made in the TER report, which stands for Tender Evaluation and Recommendation Report.
And who signs the memo?
Mr. Molefe signs the memo.
Now, may I then refer you back to page 39 of your statement, Exhibit BP 2.1A. Are you there?
Page 39 of my statement.
Page 39 of your statement,
Yes.
paragraph 88. Take us through it.
I say in page 88 that Mr. Molefe based his decision on the fact that the board had sub-delegated the authority to approve the procurement process to him as the group chief executive.
And
Yeah. I will make the point later that on a correct reading of the delegation, the board delegation, it was to whoever holds the post of group chief executive at the time the decision is taken, and not to him personally.
yes.
In other words, not to him after the incumbent or after an earlier incumbent had made the decision.
Precisely, Chair.
If he was the incumbent at the time that the decision was made, he could have done what he did, but not when somebody who had occupied the same position had already exercised the power one way or another. That's what you say.
Chair, if I can just add, perhaps to clarify
Yes,
one thing.
Yes.
Even if he was the incumbent and he exercised his authority at that point,
Yes.
based on the facts of the matter,
Yeah.
our view is it would still not have been justified
Okay.
to overlook Neotel and award to T-Systems.
Yeah, but that goes to justification. I
Yes.
thought earlier on you were talking about the authority.
Correct.
That he didn't have the authority to make a decision on a tender on which somebody occupying the same position before he took the position had already made
Had
a
already
decision.
decided.
Yes, because the one point, the latter point, goes to authority, whereas the other point you
Is
made goes to
justification.
justification.
Correct.
Okay.
Let's even put context to that to a discussion with the chair with reference to page 983 on exhibit. Yes, are you there?
I am there.
And would I be correct that this was the delegation from the board to the GCE
To approve.
to
the-
approve?
That is correct, Chair. This is the delegation, and it says that the board resolved to delegate authority to the GCE to approve the network services RFP. It was to whoever the holder of that post would say.
Yes, and an acting GCE is for all intents and
Yes.
purposes a
The GCE.
as long as he or she is acting.
That is exactly my point.
Yes. But let's even make the point even much more further. Let me refer you to page 987. Now, we now know that the board did delegate the power to the GCE, but with no uncertain terms. What you see on page 987, it's a delegation, sub-delegation to Ms. Shala Pillay. Am I correct?
That is correct, Chair.
And could you please read on the record what does it say in express terms and also emphasizing on the dates?
Chair, it says, I, Brian Molefe, in my capacity as Group Chief Executive, hereby delegate all the power of authority vested in me to Shala Pillay, Chief Executive, Transnet Pipelines, for the period 28 October 2013 to 1 November 2013. And then it just says it requires that a comprehensive report of incidents and occurrences be forwarded to my office on my return.
Yes. While keeping that page open, may I then refer you back to page 973? Now, if you look at the sub-delegation on page 987 and also look at the document, the approval document on page 973, and you look at the signature of Ms. Shala Pillay at the bottom, what was the date when she approved?
On page 973.
Yes, at the bottom.
The date is 31 October 2013.
So it fell within the dates of the sub-delegation in page 987. Am I correct?
That's correct, Chair. On page 987, she's delegated to act from 28 October 2013 to 1 November 2013.
So there's no doubt that at the time when she signed, she had all the full capacity to do so.
That is correct, Chair.
Yes. Now, may I refer you back to page 40 of your
Maybe just so that I can
follow.
follow what the issues are. As we go forward with the matter, is there any suggestion that Mr. Brian Molefe's decision to rescind Ms. Pillay's decision, or the decision that had been made before, is there any suggestion that his decision may not have been based on an understanding in good faith that he had the power to do what he did, even if that understanding may be mistaken? Is there a suggestion of anything beyond that?
Chair, there is an indication of that in the memo itself that he signed, where he intimated that on his reading of the PPM, that he was entitled to override the decision.
Okay.
So if I look only at that memorandum that
Yeah.
he signed,
Yes.
there is a suggestion that he
suggestion.
interpreted the
Yeah,
applicable
yes,
rules
yes,
so as to allow him to rescind.
yes, okay.
You do more than that, Mr. Volmink. May I refer you to page 40 of your witness statement with particular reference to paragraph 90. Are you there?
Yes.
You are saying to the chair there, in my view, the GCE's reasoning was flawed in a number of respects. He lacked the authority to take the decision. The decision itself was taken in a procedurally unfair manner, and irrelevant considerations were taken into account when the decision was made. I elaborate on these aspects below. Could you please tell us and take us through your observations in relation to the reasoning of the GCE at the time?
Yes. Chair, so I point out in my statement, and I've already dealt with this to some extent, I say first, the power vested in the GCE by the board to award business to Neotel had already been exercised by the acting GCE, Charlotte Pillay, and could not therefore be exercised again. I make the point also in paragraph 90.2, if I go down to the second sentence, I say that I agree with the views that were expressed in a certain legal opinion that was obtained by external auditors, that the board did not delegate authority to Brian Molefe personally, but rather to the holder of the post, and that when Charlotte Pillay exercised the powers as the holder of the post, she discharged the sub-delegation that was entrusted to the GCE by the board. I think that deals with the authority issue that we were discussing earlier.
Yes, you see, I'm not sure, but you and Mr. Molefe would be much more familiar with this file than I am. I'm not sure how much value there is in looking at your criticism of the decision if the idea is not to say there was no good faith misunderstanding of the position here. There was something else. So in other words, if you accept that he may have in good faith made a mistake, there might not be much value in going through everything. But if the idea is to say, no, when you look at all of these things, there was something else behind this decision, then that's different. So otherwise it becomes just a point of law.
Yeah.
You know.
No, Chair. It's more than that.
It's more than...
I did indicate
Yes,
earlier that if I look at certain paragraphs
Yes.
in Mr. Molefe's
yes,
statement,
yes,
there is a suggestion that he interpreted
Yeah.
the PPM in a way that allowed him
yes,
to rescind.
yes,
And I've explained why that is not is not correct.
yes, okay.
But Chair, the points which I make a little bit further on
yes,
is if you then look at the substance of the decision,
Yes.
leaving aside
yes,
his authority.
yes, yes,
If one considers that he bases his decision on certain risk factors
Yes,
pertaining to Neotel,
yes,
which were comprehensively dealt with
yes,
by management,
yes,
then it suggests at least a level of irrationality, or it lacks a credible basis for how that decision was made to overlook Neotel and go to T-Systems. What precisely motivated Mr. Molefe? I can't, I'm not in a position to ascribe any motives to him that I have no knowledge of myself.
Yes.
But looking at the substance
yes,
and the justifiability of the decision, it strikes me as a patently irrational decision.
And this, Mr. Mr. Mokoena, I apologize, Mr. Mokoena, this is a matter in which there is a judgment of the High Court, isn't it? T-Systems, or is that another matter?
No, it's the other T-Systems.
Oh, it's
it's the one with
few
Kajima.
T-Systems.
There are
Oh,
few.
Okay,
That's why
all right.
we're interrogating the facts of this one. They emanate from the investigations.
But you understand where my thinking
Yes.
is. You take it into account.
Definitely, Chair, but
Yes.
that's why we want to take you to the entire picture. Ultimately,
Yes.
we leave it there up until maybe
Yeah.
he chooses to put his version
Yes.
or anything else. But
Okay.
it's important for us to interrogate this facts.
Yes, no, that's fine.
Yes. Now, you may proceed. You were dealing with paragraph 90.2.
Yes,
And
and I think we've dealt with
dealt
the
with that,
issue
and I
of
want you to-
authority.
I want you to go to paragraph 90.3.
90.3, Chair, I make the point that the decision itself was taken in a procedurally unfair manner. Certain risks were identified relating to Neotel, yet Neotel is not afforded a proper opportunity to deal with those risks and to give their side of the story. And I attach a draft letter that was prepared for Neotel, where I had indicated the importance of following a procedurally fair process, asking them for their side of the story before a decision is made to disqualify them.
May I refer you to page 990 of BB, Exhibit BB 2.1C.
Yes, I am on page 990.
Is that the letter that you are referring
That
to?
is correct.
Yes. Can you take us through the contents?
The contents is that it is a letter of regret addressed to Neotel, and it says that after extensive evaluation of all bids and adjudication, we regret to advise that your company's bid was not successful. The following bidder has been afforded preferred bidder status, T-Systems South Africa Pty Limited, and we regret that your company was unsuccessful on this occasion and would indicate that this decision was based primarily on the undermentioned factors, and they mentioned business risk consideration.
Yes. We'll deal with that, the business risk component, but you also, there's a handwritten inscription inside that. Could you please take us through it?
That's correct, Chair. I received this letter, I think, for review. It was brought to me for some purpose. And I wrote this handwritten note to Mr. Edward Thomas, who was the chief group chief procurement officer at the time. And I said to him, hi Eddie, please note that in terms of section 3 of PAJA, when Transnet makes a decision which materially and adversely affects the rights or legitimate expectations of an entity, it must follow a process which is procedurally fair. In this instance, it would mean that before a final decision is taken to overlook Neotel, they must, A, be informed of the risks which the company poses to Transnet, B, be informed that Transnet proposes not to award the contract to them because of those risks, and C, be invited to make any representations to Transnet which they wish to make. Transnet must also consider such representations before making a final decision, and I refer to certain case law which deals with the question of procedural fairness.
But fundamentally, at the time when Mr. Molefe raises a justification of risk in order to overturn the decision, this is at the stage where all the risks were dealt with by management. Am I correct?
Correct.
Now, can you refer please to page 992 of the same exhibit BB 2.1C and identify that document for the chair?
Chair, this is a document which the technical experts had prepared as a response to the risks which the group chief executive had earlier identified, and they deal quite comprehensively with why those risks had been mitigated.
And would Mr. Molefe have been aware of this document at the time when he overturned the decision?
Chair, I can't state that categorically, but he would have had seen this document at some point in the process.
Yes. And the risk?
I just want to say again that we just need to be careful because if you think you have got the power to rescind a decision that has been made by somebody below you in an institution
Yes.
or a body before you, you may well feel that you are entitled to attach your own weight to different factors that need to be taken into account. So if the idea is to say Mr. Molefe, in deciding to rescind this, was motivated by factors that have got anything to do with corruption and state capture, a strong case would have to be made. So there needs to be a proper appreciation of that, because different people can attach different amount of weight to different factors and arrive at different decisions, and it wouldn't necessarily mean that a particular one has been motivated by corrupt intentions and so on. But if, of course, you can have a case where there is quite a strong case to be made. So I just want to say we need to be careful about that. Otherwise, we might spend a lot of time on what is really just maybe a nice point of law to debate, but really not having much in terms of advancing what the Commission is about.
Chair, we are looking with the witness and other witnesses at the totality of the transactions that were concluded in the similar manner, the confinements and other things which they involved Mr. Molefe. What we didn't want to do is to leave the facts which at the time governance felt so strong about them to say that they suggested quite a pattern and they also overlap to other transactions. This is just but one of them. And we understand that if we're looking at this one in isolation, maybe one might come to that debate of whether or not is this maybe a genuine error that was made by somebody who did not apply the law correctly. But this has an accumulative effect when you deal with it and analyze all the other transactions. And that's why we are dealing with it for now on the basis of Neotel, and it takes us to other transactions.
Okay.
Yes.
Okay.
But we bear that in mind. You understand what I'm saying, and it's a point we'll take it. But I think that it's quite important that we place this facts on record.
Okay.
And Mr. Volmik also felt very strong about how this matter was dealt with, and that's why we are interrogating it.
And correct, Chair. So,
and I just remind both of you that I haven't had a chance to go through all this because I didn't find it yesterday when I wanted to go through. So both of you having gone through it, you might have a better appreciation of why this might not be a case of just an innocent error of law that was made by somebody who might not be a lawyer. Okay.
Yes,
but as long as you apply your mind, both of you are lawyers, as long as you apply your mind, that's fine. When I've gone through, if I think that we are not going anywhere with it, I'll tell you.
Yes, Chair.
Chair, I have indicated earlier that I'm not in a position to ascribe any motive. I can't state that
Yes,
in,
yes.
in all
From where
honesty
you are,
as a
yes.
witness to the Commission.
Yes, yes.
What I am able to do is
Yes.
to look at the basis upon which the decision was made and
Yes.
to highlight my concerns
Yes.
that there was no, in my view, no rational
Yeah.
basis for invoking these various risks and awarding to another bidder. And that's the furthest that I can take my
Yes,
submissions.
you see, it's important to bear that in mind because you could, having regard to all of the factors that were taken into account on the basis of which the decision was rescinded by Mr. Brian Molefe, you could say this is irrational, but it might not necessarily mean there is corruption.
I
Yeah,
concede,
so it could be completely irrational, but not be corruption. But it may be that when you look at it together with maybe other things that are to follow, it might strengthen a view that even this one may have been influenced by something like that. So I was just alerting you to say, as we move forward on the issue, just bear that in mind.
Thank you, Chair.
We do, Chair. Yes, Mr. Volmink, you may proceed. You have now said that in terms of the risk being a justification to overturn the decision, that could not hold water if one have regard to what management has already done in order to mitigate the risks.
Correct.
Yes. You may proceed then to deal with paragraph 90.5 and the paragraph that follows.
Yes.
It's on page 41.
Page 41. Chair, in those paragraphs, we make the point that although the PPM allows for material risk to be considered during an adjudication stage, what it states is that the concept of material risk must be interpreted restrictively and be limited to those instances where Transnet would be severely prejudiced by the award of a business to a particular bidder. What we are trying to avoid, Chair, is where risks are invoked at the 11th hour as a reason to overlook the selected bidder when the underlying justification does not exist, and in some cases where those risks had already been taken into account during the earlier evaluation stage. So that's the point I make in page 96, and in what follows then in paragraph 90.5, in what follows, Chair, I simply question Mr. Molefe's interpretation of certain of the rules, which he said allowed him to rescind. And then I think what is most concerning is what is in 90.7, where in Mr. Molefe's statement, at least in his memorandum, he says that he will take that the further 248 million rand discount into account as a reason to award to T-Systems. And we've indicated that that should not have been the case. That process had already closed, and in fact that gave T-Systems an unfair advantage over other bidders who had not been afforded the same opportunity.
What justification did he advance for taking into account something that was done after the process had been closed, if he did advance any?
Chair, perhaps it would be better if I referred you to his statement, to his memorandum at least, my apologies.
Chair, the mic.
Sorry. In his letter of 20 November 2013 at page 990, in his letter to Neotel, he doesn't seem, if I see correctly, he doesn't seem to make any reference to this reduced price that was offered after the process had closed. Am I right?
There's no reference in that letter, Chair.
And that's one entity that should have been told if that had been a factor, isn't it?
Correct.
Because they were the bidder that had been successful in terms of of the previous decision.
Correct.
So in the letter to them, he only tells them about the business risks as the reason. Am I right?
He only mentions business risks. He doesn't mention the issue of pricing. But you asked me what was the justification for taking it into account.
Yes.
And you will find that justification dealt with in his memorandum on page 980.
It's from paragraph 21.
At paragraph 21, correct.
Yes. Can you summarize? Let's wait for the chair to
Yes,
find the page.
I'm there now.
At the bottom, Chair, paragraph 21.
Yes.
Chair, what he says is, post the close of the final offers being submitted, T-Systems indicated that they, unfortunately due to strict timelines set by Transnet, only managed to get confirmation from their shareholder on certain pricing elements, and that they would be in a position to reduce the price submitted the week before by a further 248 million rand.
But to underline there, it says post the close of the final offers.
Yes, post the close of the final offers. Over the page, he says, I approve that the 248 million be taken into consideration as part of T-Systems' best and final offer, as the commitment was made in writing to Transnet and shortly after the best and final offers have closed, and I don't believe any other bidders were prejudiced by this.
Would you agree with that reasoning?
No, I don't agree with that reasoning.
So what's the point of closing the system if anybody who comes after can be accommodated?
Precisely.
And then the others are not given a chance to come up also to compete with or match that latest offer.
Chair, it violates the principle of equal treatment, which is so fundamental in the bidding process. Everyone needs to be treated equally. You are afforded an opportunity to give your best and final offer by a certain date, and that is when the process ends, or that's when that step in the process closes. You can't then invite one particular bidder a further bite, or give a particular bidder a further bite at the cherry. It's just not right.
I guess that the least you can do, if your internal processes permit, is to reopen that for everybody. But even with that, you must check whether your internal policies and processes allow you to do that. If they don't allow you, you shouldn't reopen.
Precisely, Chair, and there's no provision in our policies that says after best and final offers and the award is to be made, now you can reopen and start the process afresh.
Yes, because they had, T-Systems had the same amount of time as everybody before the closing of the process.
Precisely.
So when they are late to put in a reduced offer, if you take that into account, it means that you have a different closing date for them, effectively.
That's exactly it.
You're extending the closing date for them.
Yeah, and you've moved out that closing,
Yeah.
precisely, yes.
And Chair, what I can also add to what you have cautioned us, that bear with us to lead the evidence of further witnesses, like Mr. Mohammedi and others that are going to follow, and dealing almost with the same issues and also clarifying certain things.
No,
Bear with us.
that's fine, that's
Yes.
fine, yeah. Thank you.
Now, yes.
Now it's going to move on, but please.
You can, you may then proceed. What then transpired?
Chair, needless to say that there was just widespread concern amongst the legal people, governance people, procurement people, the IT department about the GCE's decision. And we then thought it best to seek the opinion of counsel on the matter. And during December 2013, we arranged a consultation with Advocate Gilbert Marcus to obtain his view on the legality of the decision.
Before you tell me about his view, how long had you been with Transnet by the time this decision was made by Mr. Brian Molefe, yourself? And maybe in terms of this particular unit in which you were, had you been there for quite some time?
I think probably about 3 to 4
3 years. So, and he, how long had he been there, do you know?
Chair, I'll have to
You
hazard a
wouldn't
guess.
know.
Also a couple of.
I wanted to ask whether something like this had ever been done before, to your knowledge.
Chair, to the best of my knowledge, before this, I haven't come across.
You had never come across it.
Such as
But
this.
obviously you wouldn't know if it happened at Transnet, anything like this had happened before your time.
I can't
yeah.
say.
Okay, all right. So you sought senior counsel's opinion?
Correct.
Yes.
Chair, what senior counsel then advised is that he advised that extraneous factors were taken into account in making the decision, the award to T-Systems. He advised that the process was procedurally unfair, not in accordance with Section 217, and he advised that Transnet should review its decision to award to T-Systems and proceed with the award to Neotel. I'm giving you a summary of it, but that is in essence.
But there was also an external audit on these issues.
Sorry, Karen?
There was also external audit.
Correct, Chair. Sometime later, external audit also sought a legal opinion, which I've also attached, and the external audit legal opinion also confirmed the view that extraneous factors were considered. It raised the issue about Mr. Molefe's authority. It raised the question of the conflict of interest and the rounding off, and in essence, it also concluded that the award was not correctly made.
Now, from page 44, Mr. Volming, from paragraph 98, you deal with the not DCJ's, the GCE's decision to revoke T-System position.
Are you retaliating?
No.
Well,
It's that time of the day.
Before we get the Mr. Volming, my mind is still on the issue that in his memorandum
Yes.
on this issue of the reduced price from T-Systems that came after the process had been closed, Mr. Brian Molefe says he was approving that it be taken into account, the reduced price, the reduced offer, on the basis that he didn't think there was any prejudice to the other bidders. But I'm not sure that I understand that. Who said they would not have reduced further if they were given a chance, and if they knew that T-Systems was reducing further?
That is precisely the difficulty, Chair, because he even went on to say it is not necessary to request any other best and final offer from vendors, as all three bidders were given the opportunity to confirm their prices.
But they're not given the same opportunity.
Not the same opportunity.
And I'm just trying to think whether you need a lawyer to look at that in that way, or whether putting aside law, from a simple understanding that procurement must be fair and transparent to all
Precisely.
parties,
Chair,
you ought to see that you are being unfair
precisely.
by allowing a party, after the process has been closed, to bring in their reduced offer, and the other parties don't get given the same opportunity.
I don't think one needs to be a lawyer to see that there's a problem with this. I think just
sense
one's
of
basic
fairness.
sense of fairness would suggest that there is one particular bidder who is being given preferential treatment to the prejudice of the other bidders. And I can't see any way how that could have been justified.
Because when you say the closing date, that's the closing date. You must bring in your final and best offers not later than that date. By implication, you are saying if you bring it later, it won't be taken into account.
That is exactly right.
Yes, otherwise the idea of a closing date loses its meaning.
Precisely. Precisely.
Okay.
But as a follow-up to the chair's questions, at that stage when Mr. Molefe overturned this decision, there were already structures and individuals with authority that have applied their mind to the documentations and issues of pricing pertaining to this tender. Am I correct?
Correct. So everything was taken into account. Even that 248 million
Yes.
was brought to the attention of the evaluation team. And they said, we will not consider this because it is now after the closing date. And as I testified earlier, in my view, that was absolutely the correct decision. So that issue had been considered, all pricing issues were on the table, and a decision was made based on the pricing as at the closing date of the best and final offers.
And when he overturns this decision, does he consult with governance or any other structures, or seek clarity from any other body that dealt with the matter?
Chair, I was not consulted at all, and I seriously doubt that any other assurance function within Transnet would have been consulted before this decision was made.
Now, from page 44, paragraph 98, you deal with the GCE's decision to revoke the T16 position as a preferred bidder. How does this now happen?
Chair, so after the external audit finding was made, and as I said, it was accompanied by a legal opinion as well, the GCE then relented, and he decided he was going to revoke T-Systems status now as the preferred bidder. And a letter was written to T-Systems to inform it of the GCE's decision to revoke its appointment as the preferred bidder.
So firstly, he overturns the decision to award the tender to Neotel,
Correct?
and he does that alone.
He does that alone.
And now he revokes the decision that he has made to award to T-Systems.
Yes,
He
that
revokes
is
his own decision.
correct. That is what he did.
And that is after he had been finished with senior counsel's opinion and other reports.
Chair, he would have been furnished with the audit, the external audit finding. On senior counsel's opinion, I deal with that as well in my statement. There was apparently a request made not to obtain the final written opinion from senior counsel.
So is the position that, as far as you know, the senior counsel's opinion was not brought to his attention for whatever reason?
For whatever reason, Chair,
Yes.
senior counsel So written opinion
Yes.
was not
Made available
was not
to him.
made available.
Yeah, and you'll deal with the reasons
I
later.
deal with
Yeah.
that also in my statement.
Now, can we proceed to deal with the confinement of the CCTV security upgrade contract to Neotel? You are
So-
dealing with...
I'm sorry,
That's fine.
Mr. Mkwena. So the revocation of his decision to award the tender to T-Systems was, as far as you know, based largely, if not solely, on the audit report.
Or on the audit file.
Yeah, okay, all right.
Yes.
Thank you.
Chair, maybe for completeness, in relation to that question, may I refer you to page 1051. So as at least we can deal with this matter on its factual basis and to see what Mr. Molefe communicates to T-Systems. Could you identify that letter, Mr. Volmink?
On page 1051, it's the letter written by Mr. Molefe to T-Systems.
And what does he convey to them?
It says that we refer to your letter dated 20 May in response to Transnet's stated intention to revoke your status as preferred bidder in respect of network services tender. Transnet considered your representations as set out in your letter and hereby wish to inform you of our final decision, which is that your preferred bidder status has been revoked.
And nothing more is being said.
Yeah. nothing else.
Now, I was referring you to page 45. Now we are dealing with the confinement of the CCTV.
Yes.
Can you please take us through?
This is the next transaction that I was asked to consider and to comment on, Chair. And it relates to a confinement to Neotel regarding a CCTV upgrade or the upgrade of CCTV cameras and equipment within the ports. And what I say in paragraph 103 following is that a confinement for a contract for CCTV upgrade to Neotel was submitted by Mr. Tau Morwe, who was the chief executive of TNPA, and it was approved by the group chief executive at the time, and a copy of that confinement is then addressed. I make the point that I also don't recall any stage where the governance function was asked to review the confinement, and I'm not able to find any record of a prior review.
May I refer you to page 1066, Chair? It's Exhibit BB 2.1C.
Did you say 1066?
1066, Chair. Can you please ID that document for us?
This is the memorandum requesting confinement, which was submitted to the group chief executive.
Yes, and what is the date of the memo?
The date of the memo is the 24th of April 2014.
And the subject?
The subject relates to a request for approval to procure a CCTV security solution for TNPA across all ports.
Can you please take us through the contents under the purpose?
So, under the purpose of the submission, it says that the purpose is to request the group chief executive to approve the award, to approve and award business for the procurement of CCTV cameras and related maintenance through a confined procurement process to the value of 142 million and some change from Neotel. Secondly, the award of business via the current Neotel Master Services Agreement for the installation of the CCTV and security solution to the value of 186 million allowing sole accountability to Neotel for effective working of the solution, and then to approve unforeseen capex in the value of 252 million.
Now, let me refer you back to your witness statement on page 45, and you may proceed dealing with the contents of paragraph 104 onwards.
So, in paragraph 104, Chair, I make the point that the memo provides a motivation for confining the procurement of the CCTV cameras to Neotel, and for awarding this business via the existing Neotel MSA for the installation of the cameras. And I make the point that the grounds for the confinement were stated, well, there were two grounds basically. Firstly, there was urgency, and secondly, compatibility with existing products and services. And I say that I was asked by the Commission's investigators to provide my comments on the grounds of confinement, in particular whether they were sound or not sound.
Yes, can you proceed?
Then as far as urgency is concerned, Chair, this is where I had a difficulty because the main difficulty that I had with this is that the urgency was not unforeseen. The PPM specifically says that it must be an unforeseen urgency. You can't see the urgency coming on way down the road, and then at the last minute you invoke urgency. And I make the point in my statement in paragraph 104.1, I say that the ground for confinement, as stated in the PPM, is that confinements will only be considered where a genuine urgency has arisen, which should not be attributable to a lack of proper planning. In such cases, appropriate action must be taken against the individual responsible for the bad planning, but you can't use that bad planning as a basis for urgency. It's the conversation that we had earlier. And I make the point also in paragraph 104.3 that the factors mentioned for urgency were entirely foreseeable. And a few, I think there's probably about 3 factors that were mentioned. The first is that TNPA could be non-compliant with certain international shipping and port facility security codes. Now, if I can pause there for a moment, it is said that we could be blacklisted by the U.S. administration, and it mentions various consequences which could arise if the CCTV cameras were not put in place. And it occurred to me, Chair, that one doesn't realize now all of a sudden that we are non-compliant with these codes. If we read this statement as a whole, some of these CCTV cameras had been defective for a very long period of time. And the urgency which now exists was not an unforeseeable urgency. So based purely on a cold reading of this document, I came to the conclusion that it could not be said that this was an unforeseeable urgency. The second factor pertains to insurance claims. There was a concern that our insurers may not cover us if there's any incident which happens in the ports because of our defective equipment. But once again, that is not unforeseeable. It's not as if we realize today that the insurers will not cover us for defective equipment, when in fact this is a situation that has been coming on for a very long time. And the third reason, which in my view was the weakest of all the reasons, pertains to the fact that certain PFMA reportable items had to be remediated. I mentioned that in paragraph 104.3. And apparently this relates to the fact that a company called ESS had installed this equipment at some point in the past, and that this had created fruitless and wasteful expenditure or irregular expenditure. And the memorandum suggests that it is urgent that we take remedial action to address the PFMA issues. Now, I say it's the weakest of the reasons, Chair, because the way one has to remediate a finding of irregular expenditure or fruitless and wasteful expenditure is by taking disciplinary steps against the person or persons who are responsible for that having occurred, and possibly instituting civil or criminal action. But I could not understand why those factors were put forward as a grounds for urgency. Having said that, I thought that the second ground, which is compatibility with existing products or services, I thought that that ground was plausible. It was a credible ground. We are going to Neotel, who has the network services contract, and the CCTV cameras have to interface with the network which they have put in place. There needs to be interoperability between the CCTV cameras and the network system. So I felt, in fairness, that I couldn't take issue with the second ground, but I was quite concerned about the first ground. Yes.
And if there was one ground with which you took no issue, would that be good enough for purposes of justifying confinement?
That's an interesting question.
Mm-hmm.
The PPM certainly doesn't say that.
Doesn't prescribe.
It doesn't prescribe. It says all your grounds must
Yeah.
must be correct.
Mm.
Having said that, I am aware of some authority for the view that if reasons are given for a decision, and one of which is defective, it infects the validity of the decision as a whole. So that is a concern as well.
Yeah, well, I think I know what you're talking about. I know that as well. But I'm not sure that it's logical. And I say that not knowing whether I've ever been party to a decision such as that. If you have got 3 or 4 reasons why you say that something is good, these reasons may have different weight. You might have one that may be good enough, that would have been good enough even if you didn't have the other 3 on which to base that, to say this thing is good. You might have 3 or 4 reasons which, each of which on its own is not good enough to sustain that view, and therefore can only stand if you have the other reasons as well. Just like you could have a reason that makes a particular decision fatally defective on its own. You could have a reason that sustains it despite how weak the other reasons are, one would think. But maybe that may be a debate for another day. So anyway, but for this particular job that you were performing, what was your view? Was it whether the fact that on compatibility, since you could not take issue with that should sustain, that should be okay, or is it something you took no view on?
Chair, I was asked to express a view on whether the grounds for confinement were valid or invalid. I haven't expressed a further view whether if one ground is found to be invalid, whether it taints the decision as a whole. So I confined myself to the task that was set for me, and I commented that I thought one ground was invalid, but the second ground was valid.
Yeah, okay.
But Mr.
Well,
Volnik, maybe I have read a statement 5 times more than you. Even that ground that you said you may find as a justification, when you go to paragraph 1045.5, you seem not to be convinced about the very same ground of compatibility. And can you please take the chair?
Yes, perhaps I should take the chair through that. So I'm saying I don't agree with the ground of urgency. I think that there was sufficient ground to confine to Neotel on the grounds of compatibility. But where I take issue with with what then follows in the memorandum is that mention is then made of the fact that this CCTV equipment had to specifically be sourced from a company called NICE, N-I-C-E, and that Neotel had recommended that NICE equipment be obtained because NICE was prepared to give certain guarantees and warranties and so on. But as I said, the memo then also goes on to say that this very NICE equipment had reached the end of their useful life, that there was a 64% failure rate of the equipment. I understand the motivation to confine to Neotel, but it certainly wasn't necessary to then say, oh, and Neotel will also obtain or procure this from this other entity, which was not the subject matter of this confinement. I think that is the point that I'm trying to make.
So what you are saying is, whatever it is that you are saying in 104.5 doesn't relate to whether confinement is justified or not. It relates to whether NICE or whatever they are called, their equipment could be used. That's where what it relates to.
I raised that question. I say I don't understand why we have to be talking about this NICE or NICE equipment.
Because that has got nothing to do with confinement.
It's got nothing, and in any event, you've already said that their confinement is non-functional and so on.
Okay.
Now, on paragraph 1046, you also deal with the discoveries that you made pertaining to Neotel. Could you please share that with the chair?
Yes, Chair. I think sometime after the award, we discovered, or it was discovered that Neotel was actually not registered as a security service provider with the Private Security Industry Regulator, and the Act, the Private Security Industry Regulation Act, requires registration before any security services can be performed. And security services includes things like the installation of CCTV cameras. We did write a memorandum setting out our concerns around the award to Neotel based on their non-registration with CIRA. Apparently, the Minister of Police exempted Neotel then from the requirements of CIRA, and a contract was then concluded with Neotel.
But could that exemption also be applicable to Transnet?
No, the exemption would have been applicable to the entity who was supposed to be registered.
Yes.
So the minister exempts Neotel from that particular requirement, not Transnet.
Mr. Chair, we are about to deal with another long topic of the T-Systems Award, and I see it's 1551 or if not 1553. Maybe deal with this tomorrow, and I can assure you that we will be able to finalize the evidence of Mr. Volmik tomorrow before 1 o'clock. Even if we start at 10 o'clock, we'll still be able to finalize it.
Oh, you don't think we need to go up to 4? Or so you think there'll be enough time to
There'll be
finish
enough
tomorrow?
time, definitely.
Okay, and if we start what time tomorrow?
Even if we start at 10 o'clock,
Even if we start at 10?
we'll be able to finalize the evidence before 1 o'clock.
Okay. Okay, no, that's fine then. Okay, then that's fine. Let's adjourn then, and we'll start at 10 tomorrow morning. So we adjourn then.